Assalamualaikum and a very good morning. I am Sharija Shaari from the Faculty of Business, Economics and Accountancy. I am going to present a paper entitled Realigning Occupational Safety and Health Legislation with Flexible Working Arrangements. My co-researcher is Sharifah Rahama binti Amirul and my ID is FPEP03. My comments, I would like to express our gratitude to UMS for funding this study. So this study is under UMS grant SDK 0177-2020 entitled Embracing Flexible Working Arrangements Post-COVID-19, a Social Legal Study. So this is a combination between law and human resource. So this is my outline. Okay. Prior to pandemic, the private sector in Malaysia is not familiar or is not supporting working from home. Okay. However, due to the pandemic, they have no choice. Okay, so working from home is one of the flexible working arrangements. Okay, so in order to ensure the livelihood of the company or the organization, they have to resort to working from home. Otherwise, they will face financial distress. So the objective of this paper is to dwell on the issues relating to OSH and FWAs, particularly working from home. So it is hoped that this study will be able to fill a gap in the literature. And however, this study will only confine to the existing OSH legislation upon working from home. So this is the methodology. So I'm using the social legal methodology, okay, meaning that it is the legal method which are using social sciences approach. Okay, so I use okay, so I have to refer to the acts and interpret the acts and support by cases if there is any cases. So this is my legal analysis. Okay, the common law, meaning the cases have been decided. Okay, in court, so we have to know the hierarchy of courts. Okay, so meaning that reported cases are only the cases in superior courts. So superior courts in Malaysia start with High Court. Okay, High Court and Court of Appeal and Federal Court. Okay, so based on common law and also Section 15 Occupational Safety and Health Act, which is later referred to OSHA 1994, provides that it is the employee's duty so far as practicable to ensure the employee is being trained to perform his work safely. So the key word here is so far as practicable. And apart from the underlying duties in OSHA 1994, there are also regulations that are related to working from home, as you can see from the screen. So however, here, when the workers are allowed to work from home during pandemic, so therefore the hazard changes, because the hazard that is that you can find in the workplace may not be applicable at home, and there might be new hazard for those working at home. So that is why we have to revisit the OSH requirements to address concerns that arise from working at home. So as I said earlier, changes in the working arrangements, that is working from home, impose an unknown OSH hazard to the employees. Okay, so a question is posed here as to what extent are the employer's obligations to ensure the safety of the employee while they work from home. Okay, so the duty of the employer is so far as practicable, meaning that we have to refer to Section 3. What does it mean as practicable? Okay, so we have to take into how often, and the cost, and so meaning that in layman's word, it means that a reasonable. What are the reasonable precautions or steps or measures that employers have to take to ensure that the employees are safe while they're performing work at home? Okay, so I have here our our discussion is working for employers need to have a working from home safety policy. So the question is that how many employees do have? Because at times, especially the small companies, it is based on ad hoc. So when the government announce MCO, only then they will ask the employees to work from home without having proper thought of what are the safety policy that can be used for the employees working from home. And also the question is that whether the employees are trained to identify the hazard and do the risk assessment and risk control for any hazards that they might encounter while they are performing work from home. So this is known as hierarchy. So this is another question, whether the employees are trained to do hierarchy or not. And what about the health and welfare? When it comes to health, sometimes working from home is more tiring because sometimes the bosses, they did not have they simply call or simply message at odd hours, and because the law in Malaysia, we do not have a specific law concerning working from home, so that's why there is no law that say the employees have the right to disconnect. But this is just based on trust between employer and employees. So in long term, it will not be good for the employees. Because it might create to mental health issues. Because their anxiety. They might cause anxiety because employers call them in the middle of midnight, asking them to submit the documents and so forth. And what about the welfare? When it comes to so these are interrelated, health and welfare. So next issue would be ergonomics issue, meaning that whether the furnitures, the desk used at home is suitable for the employees to sit for long hours, because not everyone is fortunate enough to have a specific study area or specific office space. So most of the employees will use their dining table as the workspace. So the question is that dining table is not meant to be used for long hours, so it might later on lead to economic issues, which later on might lead to health issues, maybe back pain and so forth. And another point, so if there is any incident or near misses at home, so the employees are required to inform the employers as soon as possible, and the employers are required to notify DOSH depending on the severity of the accidents. So another point is meant by notification of accident, dangerous occurrence, occupational poisoning, and occupational disease. And then next we are going to look at employees' legal duties. Employees' legal duties are provided in Section 24. So it prescribes that employees must cooperate and comply with any instruction instituted by the employers in discharging their duties. So this relates to the issue which I've mentioned earlier on when it comes to the right to disconnect, because there is no specific law in Malaysia that allows or that prohibits employer from contacting employees at odd hours. So the employees are also entrusted with duties to take reasonable care for his safety and health. So meaning that it is his own duty to ensure that he is safe while performing work at home. So failure to do so, let's say he might suffer injury. But normally for working from home, the possible injury could be related to health and welfare and economic issues. But there might be fire, or there might be short circuit. So this is where hierarchy is very important. So what is the implication? So there are two implications that we can think of. First one will be the implication for existing knowledge, which our findings will provide an additional new literature, and also we are trying to bring to light the interrelationship between FWAs and OSH, which has yet to be explored, okay, by Malaysian scholars. Okay, when it comes to for the practical implications, okay, so dealing with working from home is still a green area in Malaysia. Okay, so meaning that, okay, there must be a specific policy, okay, in private sector. Okay, at the moment, it depends on their respective employers to come up with a policy. Okay, but for government sector, okay, it is already in place. Okay, so the presentation today is meant for private sector, not for the public sector. Okay, so a change, okay, in the mindset of those in private sector is very crucial, okay, for an effective policy to be successful, because prior to COVID-19, the private sector, okay, they are very reluctant to allow employees to work from home. And similarly, employees in Malaysia also are not that keen to work from home. Okay, because they fear that there will be stigma, they will be labeled as lazy, they will be, let's say, in the event of restructuring, they will be the first one to be kicked out from the organization. So that is why the change of mindset is very important, that working from home should be allowed to those who like to choose it, okay, for their own reason. Okay, in developed countries, people choose to work from home, okay, way before pandemic, because, okay, especially for those who have to take care of their young children or parents, okay, so they will go for working from home. Okay, but such a situation is not really rampant in Malaysia. So in conclusion, okay, working from home pose unique challenges for Malaysian employers. Okay, so now they are receptive towards working from home, but we hope that after COVID-19, they were still receptive towards working from home, as, okay, as what they are doing now. Okay, so the question arises is that, okay, can employee who work from home seek compensation? So that is why SOCSO comes into the scene here. Okay, so the Social Security Organization must relook, okay, their conditions, okay, their act also to allow those working from home, okay, and suffer from accident, okay, and therefore they should be protected as well, because they work from home with the approval from their employer or as instructed by the employer due to pandemic. Okay, so meaning that SOCSO must be aligned, okay, to accommodate those who work from home. Okay, so therefore, we would like to suggest further research, okay, to conduct the effect, okay, for of working from home upon SOCSO as well. So with that, I thank you.